Mr. Brock. Mr. Brock, sir, you have 4 minutes.
Thank you, Chair. I'd like to thank both professors for your attendance today. To you, Dr. West, the Prime Minister promised Canadians when he formed government that he would run an open and transparent government. He agreed to cooperate fully with Justice Rouleau when asked to testify. Yet he and his cabinet have hidden behind the principle of solicitor-client privilege in not releasing the legal advice he received. A just trust us argument is unacceptable to Canadians. Without the benefit of that opinion, you opined in a legal article, and this was co-authored by yourself, Michael Nesbitt, and Jake Norris in the the Criminal Law Quarterly, that for the government to have properly justified the declaration of a public order emergency, the government needed to base its invocation on 3 novel, unconventional, and previously unanticipated ways of interpreting this legal threshold. Can you opine on that? And the secondary question to that is, this article was written before all of the evidence was heard. Does your opinion still stand? If not, how does it differ?
So it changed slightly because we wrote that on the basis that Section 2C was being interpreted as we would interpret it in the CSIS Act. So that's what we were assuming, that when Cabinet read 2C, they read it the same way that we would have. And so not having any evidence at the time the article was written that there was such serious violence or threats of violence that would amount to 2C, we said, well, there must be some novel way of interpreting what serious violence means. And based on the Section 58 justification, we looked at what was there, and it was serious economic harm in particular. Now we've heard that it wasn't the serious economic harm, it wasn't intelligence or evidence that wasn't available to the public. It was a different definition of 2C that was relied upon, and that was something that we had not anticipated when we wrote that article.
Okay. You appeared on CBC Power and Politics on a number of occasions during the Rouleau Commission, and the question that was put to you and another professor was what we learned from the Prime Minister's testimony. I also looked at your Twitter feed, and in a tweet in and around that same time frame, this is probably during the day or perhaps the day after the Prime Minister testified, in a tweet you said that Trudeau, Prime Minister, is making a compelling argument if you're not a lawyer. Please expand on that.
It's a lot to unpack. Basically, yes, thank you, is that what I heard and what I've heard all the way through as someone who's trying to take the facts and the understanding and apply it to the law is a lot of facts being applied to different elements of the definitions, but they're not ever necessarily in the right order. They're not, you don't meet the first hurdle before you get to the next one, before you get to the next one. They're all kind of, they're just applied as if there's not a structure to the act. So you get facts that talk about one element of the definition and then facts that talk about another, but they don't really lay it out in terms of you have to meet this threshold and this one and this one. And so I think if someone's just reading the act and isn't, someone who's a statutory interpretation nerd, you look at it and you're like, oh, well, all of the things here match up with all of the things that are in the act, so that makes sense. But that's not the way the statute's laid out. There's a series of thresholds that need to be met, and they're, each word matters. And that's why I found, compelling, but not if you're looking at it with, this through the eye of someone who's keen on statutory interpretation.
For those who may be keeping track, I am allowing the witnesses to finish their thoughts and their answers, but your intervention has been completed.